Welcome to the CCN Mexico Report podcast, an overview of Mexican legal, business, and political developments presented by the international law firm of Cascio, Cavazos and Newton. The content presented is for information and educational purposes only and should not be understood as legal advice.
Welcome to the CCN Mexico Report. I'm Rob Barnett. Mexico's Supreme Court has ruled on the constitutionality of a 3-month salary cap for employee profit-sharing payments. Pablo Sainz, Fernando Govea, and Mayra de Luna write, in Amparo Case 633-2023, dated April 3, 2024, the Second Chamber of the Mexican Supreme Court confirmed the constitutionality of a cap on employee profit-sharing payments amounting to 3 months of an employee's salary, or the average of profit sharing received in the last 3 years, whichever is more favorable to the employee. The court's decision stated that the terms of Section 8 of Article 127 of the Federal Labor Law do not violate the Mexican federal Constitution or the Guide for Complying with Employee Profit Sharing Obligations issued by the Department of Labor and Social Welfare. The Second Chamber of the Court, by a unanimous vote, emphasized that the Mexican Congress has the power to legislate on labor matters and issue rules regarding employee profit sharing. Finally, the ruling clarified that the 3-month cap is not absolute, since the guide leaves open the possible interpretation that an employee who has not completed 3 years of employment may rely on the average amount paid to employees of the same category, post, title, level, or position of the employee during the last 3 years. As a result, the cap limiting the amount of employee profit sharing is variable and will be awarded in the employee's best interest pursuant to the following terms. 1, 3-month salary, or 2, the average of profit sharing payments received in the last 3 years, or 3, in the case of an employee who does not have 3 years of seniority, the average amount paid to the same category, post, title, level, or position during the last 3 years will apply. Mexico has published a new Alternative Dispute Resolution, or ADR, law. Abel Quesada and Jorge Sanchez Cubillo write that on January 26, 2024, the long-awaited General Law on Alternative Dispute Resolution Mechanisms, the new law, was published in the Official Journal of the Federation. All of this in compliance with the 2017 constitutional amendment that made alternative dispute resolution mechanisms a constitutionally protected practice in Mexico. The new ADR law seeks to regulate and harmonize the practices of parties using alternative dispute resolution mechanisms, including mediation and conciliation, taking into account Mexico's various state laws that apply to dispute resolution. The new ADR law is projected to be a useful tool in standardizing mediation and conciliation throughout the country, as well as to update numerous procedural issues, such as the use of electronic media and general principles governing mediation and conciliation. These updates were necessary given previous differences in certain definitions and requirements found in Mexican state laws. Despite the significant achievement the new ADR law represents for issues of access to justice, freedom of the parties to resolve disputes, and a potential solution to the immense judicial burden that exists in the country, it does contain certain aspects that may potentially hinder its application. The new ADR law may tend to overregulate the activities of mediators, especially private mediators. This could occur through adding a series of requirements mediators must meet to be certified, as well as to negotiate mediation agreements and to execute these agreements. Another potentially adverse aspect of the law can be found in its Article 35, which provides that mediators incur civil liability for deficient or negligent preparation, execution, or registration of mediation agreements. This type of provision transfers to the mediators an excessive risk burden beyond their control in a wide range of possible situations, which will possibly discourage the practice of mediators and with it a reduced availability of alternative dispute resolution mechanisms. As Winston Churchill said, If you have 10,000 regulations, you destroy all respect for the law. Regardless of any shortcomings, the new ADR law confirms the constitutional right in Mexico to opt for alternative dispute resolution mechanisms, with a series of novel procedures and provisions regulating their use throughout Mexico, all in an attempt to avoid the parties having to resolve their disputes through lengthy and costly judicial proceedings. In an article entitled How Foreign Investors Can Use U.S. Wills to Accomplish Their Estate Planning Goals, Marisa Sandoval Rodriguez writes that when it comes to cross-border business ventures, the importance of estate planning often remains overshadowed by immediate investment considerations. However, for investors eyeing opportunities in the U.S., prudent considerations of estate planning is important. While some may have made estate planning arrangements in their native jurisdictions, the adoption of a U.S. situs will is a strategic option which may be used to ensure the seamless transition of U.S.-based assets, including real estate holdings, financial portfolios, and tangible properties. The U.S. situs will is an underutilized yet efficient legal instrument, offering foreign investors a streamlined avenue for implementing and executing estate plans involving U.S. probate assets in a cost-effective and expeditious manner, as compared to relying solely on foreign wills. Key benefits of the U.S. situs will include its drafting in English, ensuring clarity and comprehension by U.S. institutions, its adherence to local legal norms, and engendering familiarity with U.S. local authorities. All of this eliminates uncertainties inherent in foreign documents drafted under unfamiliar legal frameworks. This legal tool grants foreign investors the ability to dictate asset distribution in line with their preferences and estate plans, in ways that may not be available within their home jurisdictions. With a U.S. situs will, foreign investors may designate the disposition of interest in real property, personal property, and trust beneficiaries distinct from those stipulated in their foreign wills. They may establish trusts for minor heirs and nominate executors for efficient estate administration in the U.S. An executor named in a U.S. situs will should be someone who is either in or can travel to the United States to handle estate matters. It is crucial to engage legal counsel with international estate planning proficiency to ensure seamless alignment with global objectives while avoiding the inadvertent revocation of existing testamentary instruments. While many state laws, such as those of Texas, recognize the validity of foreign wills and provide for the probate of foreign wills in the U.S., probating a foreign will in the U.S. is typically more costly and time-consuming than probating a U.S. situs will. Heirs must often wait until the probate proceeding is finalized in the foreign testator's home before initiating a probate in the U.S., and will have to navigate additional obstacles, such as finding an attorney with experience in probating foreign wills, obtaining authenticated probate records from foreign probate proceedings, and having them translated to English. Despite its advantages, the U.S. situs will does not shield against the impact of the U.S. estate tax, which can reach up to 40% and applies to both U.S. citizens and foreign investors. The tax implications, contingent upon domicile, necessitate strategic planning. With the current exemption of over $13 million for U.S. domiciliaries versus only $60,000 for foreign residents, foreign investors should seek guidance from legal and tax experts well-versed in representing international clients. In summary, embracing U.S. situs wills is a savvy approach for international investors seeking to safeguard their U.S. assets and optimize estate planning efficiencies. By proactively addressing legal nuances and tax considerations, investors can mitigate risks, preserve wealth, and ensure a smooth asset transmission in line with their personal and business objectives. Mexico has amended its rules for issuing electronic negotiable instruments. Iker Diegues and Eduardo Parroquin write that on March 26, 2024, the Mexican government published a decree amending, supplementing, and repealing various provisions of the General Law of Negotiable Instruments and Credit Transactions, and the General Law of Organizations and Ancillary Credit Transactions, published in the Official Journal of the Federation. The decree is important because it expressly adds to the Negotiable Instruments Law a provision that was already provided for in the Mexican Commercial Code, stating that any document may be issued electronically through the use of an electronic signature, including negotiable instruments such as promissory notes, stock certificates, and/or certificates of deposit, among others. The decree also modernizes the use of certificates of deposit by general deposit customs warehouses. In this regard, it should be noted that throughout the legislative process leading up to the decree, the intent was to benefit activities of the country's agricultural sector, facilitating certificates of deposit to be issued electronically and through a cryptographic system managed by general deposit customs warehouses, in which Mexico's advanced electronic signature is required to be used, as opposed to another digital signature. This should facilitate access to agricultural credit by making it easier to utilize these instruments. This amendment should be interpreted with caution and accompanied by a careful review of the implications that the electronic issuance of a negotiable instrument could have in each specific case. At present, its use for certificates of deposit is regulated in detail. However, it is important to consider that the decree constitutes a major step forward in this area, since the option to pursue an electronic credit instrument is now explicitly permitted. In the end, one should keep in mind that only the issuance of electronic certificates of deposit have been regulated in detail, and that no specific regulations have been issued for any other types of negotiable instruments. Therefore, the delivery, request for payment, endorsement, cancellation, or payment of electronic certificates of deposit will depend on technological advances in the criteria of legal authorities responsible for regulating these instruments.
Thank you for joining us for this edition of the CCN Mexico Report podcast. Subscribe to the CCN Mexico Report newsletter at www.ccn-law.com to receive the full text of this edition's articles. This podcast is copyrighted 2024 by Kashoka Vasos & Newton, LLP. All rights reserved.